Good day, Crime Talk aficionados. It is Saturday, October 23rd, 2021. What does that mean? Well, it's the weekend, means it is a weekly recap of all of the top stories from throughout the week here on Crime Talk. Enjoy, watch all of the previous episodes in their entirety. Please do. Thanks for watching, and we'll see you next time on Crime Talk. All right, ladies and gentlemen, let's get to the docket. First on the docket, a very important case is commencing in Georgia. That's right, it's the trial regarding the death of Ahmed Arberry. So, a Georgia town is preparing for the murder trial of three white men charged with killing Ahmed Arberry, a 25-year-old black jogger whose shooting was captured on video last year. Greg McMichael, 65, his son Travis, 35, and the neighbor William Roddy Bryan, 52, are accused of killing Arberry after spotting him running in their neighborhood on February 23rd of 2020. Now, Bryan filmed part of the shooting in a video that sparked national outrage over a lack of arrests for more than 2 months. Now, Arberry was shot 3 times at close range with a shotgun. And defense lawyers for the McMichaels say they were trying to make a citizen's arrest because they believed Arberry was a burglary suspect, saying Travis McMichael shot Arberry in self-defense. Arberry was shot in the Satia Shores neighborhood in Brunswick, a small Georgia town about 70 miles south of Savannah. Now, no arrests were made in this case for more than 2 months until a video of the incident, shot by defendant Bryan, was released by his then attorney. It was sent to a radio station and they put it up on their website. Now, Mr. Arberry, I hope that for the attorney's sake, I guess, that you gave consent to release that video. And I'm sure you did because you thought it was going to help you. But it turned out, that's right, to basically be the best evidence against you. Now, in the short clip, a white pickup truck blocks the view of the beginning of the struggle. A gunshot is heard, then Arberry and Travis McMichael are seen with their hands on a weapon that is angled upward toward Arberry. The struggle again goes out of view and Gregory McMichael is seen in the back of the truck. A second shot is heard and the camera shifts back to the fight where Arberry is throwing punches. A third gunshot is heard and Arberry falls to the ground. Brunswick, Georgia, which has just over 16,000 residents, is predominantly black, but sits in an overwhelmingly white Glynn County. Now, the charges against the three men, the McMichaels and Bryan, they've been charged with malice murder and felony murder, 2 counts of aggravated assault, and 1 count of false imprisonment and criminal attempt to commit false imprisonment. The trio are not facing state hate crime charges because Georgia didn't have hate crime laws at the time, but they have been federally charged with violating Arberry's civil rights. The 3 men are also facing a wrongful death civil lawsuit from Arberry's mother, Wanda Cooper Jones. The murder charges could result in a life sentence. The aggravated assault has a maximum sentence of 20 years in prison. False imprisonment is punishable by up to 10 years in prison. Now, if the defendants are convicted of multiple counts, they'll be sentenced to the most serious charge as the charges will in fact merge. This is going to be an interesting case to watch. There are going to be lots of legal issues, specifically as it comes to the jury instructions that are going to be given. It will be unlikely that the defense can actually get the self-defense instruction unless, well, somebody testifies and says it was self-defense. That would be, obviously, the younger McMichael. Additionally, there's going to be issues as it relates to whether the defendants are going to be able to get this good citizen, good faith law, which allows them to make citizens arrests. I've read the statute. I don't believe that's going to be the case because I don't believe the evidence is going to show that these men knew or actually were aware that a burglary was taking place. Speculation is not enough. It's going to be an interesting trial. Hopefully, both sides get a fair trial, and hopefully, well, the jury will do the correct thing and that's based upon the evidence that's legally presented to them to consider when following the law. Obviously, if there's a conviction, there will be an appeal. Next on the docket, Alex Murdoch. He's home again. That's right. And guess what happened? Well, Alex Murdoch was denied bond Tuesday after facing new charges tied to the embezzling of millions of dollars related to the death of his housekeeper, Gloria Satterfield. Now, police arrested Murdoch in Orlando, Florida on Thursday and charged him with 2 felony counts of obtaining property by false pretenses, which carry a maximum sentence of 10 years in prison. Now, Murdoch, 53, was wearing a mask and wearing a jail jumpsuit, did not speak during the hearing. And during the bond hearing, the prosecutor, Creighton Waters, said Murdoch had promised to keep Satterfield's sons financially secure after her death by paying them financial proceeds from a life insurance policy. But instead, Waters said, Murdoch set up the sons with another attorney, Corey Fleming, a close friend and former college roommate, to represent the family's estate. The son maintains that they were unaware of the pair's friendship. Waters said that Fleming helped to divert millions of dollars to an account set up by Murdoch for a fake company called Forge, which was named after a legitimate financial consulting company unaffiliated with the case in any way. Well, Circuit Court Judge Clifton Newman ordered Murdoch to undergo a psychiatric evaluation following concerns he presents a potential danger to himself and the community. What does that really mean? Well, there's probably been some talk of suicidal ideations, and so they're going to make sure he's not going to hurt himself so that we can try him, prosecute him, get to prison, and then he'll hurt himself. Or all the people that he helped prosecute and his family helped prosecute over the years will then hurt Mr. Murdoch for themselves. Now, as you may recall, Mr. Murdoch had already been out on another $20,000 personal recognizance bond in September and was allowed to continue treatment at an out-of-state drug detox center for an alleged opioid addiction. Now, we certainly wish Mr. Murdoch the best in his battle with his opioid addiction, and we will obviously give him the presumption of innocence. However, we've said it once, we'll say it again. Yes, the wheels are coming off of Alex Murdoch's life. And obviously, the true victims here are obviously everyone that's been allegedly scammed through his fraudulent conduct, and obviously his deceased wife and deceased son. But even worse is his living son, who has basically had his whole world turned upside down through no fault of his own. He's probably found out that he has no money, that his family has no money, and anything that they have is going to be taken away by creditors who basically are entitled to money from Alex Murdoch. So it's getting ugly, but it just shows you, ladies and gentlemen, when somebody does in fact commit crime, the real victims, are not the ones that show up in court. The ones that suffer are not the ones going to prison. If Alex Murdoch goes to prison, he'll be getting, 3 hots and a cot, 3 meals, a place to live. Basically, all his troubles will go away. He just has to kill a little time. It's the family that's going to be left behind to clean up his mess and all the repercussions that come with that. Those are truly the victims. And obviously, in any financial crime, people somehow think it's not as serious as violent crime. But when people take and steal all of your money, you literally sometimes have to wonder, am I going to be able to recover from this? So Alex Murdoch will give you the presumption of innocence, but man, not looking good for you. We'll see how things turn out. Next on the docket, Barry Morphew goes on the offensive. Barry Morphew, through a new set of attorneys, civil attorneys, filed a notice of intent to sue the prosecutors, the investigators that are handling his case. Why would you say? What cause of action could they possibly have against the investigators and the prosecutors? Well, the defense is saying that the prosecution was aware of and basically withheld exculpatory information, and they didn't release it to them until after the preliminary hearing. Now, I remember mention at the preliminary hearing about some DNA that was found inside the glove box of Suzanne Morphew. it was a mixture and not a whole lot was gone into it. I think there were some questions about whether some leads were followed and that was it. Well, it turns out apparently the prosecution may have had some information and hadn't turned it over. Well, you can't do that. And there's actually a new law here in Colorado that basically allows you to sue public employees, and they're both official and individual capacity, when you commit violations of constitutional rights, right? The prosecution has a duty to turn over all evidence, even if it doesn't help them. Now, could this also be related to the fact that the lead prosecutor on the case was suddenly leaving rather abruptly? Was it because he was aware of it, didn't turn it over, or he became aware that somebody was aware of it and turned it over? Needless to say, he's leaving. Now, no actual lawsuit has been filed. It's just simply a notice of intent to sue, which is required before you sue any public officials or governmental agencies in the state. It basically gives them notice so that, items aren't destroyed, witnesses are preserved. It's basically like a preservation letter for everybody. But it clearly shows that Barry Morphew and his attorneys are going on the offensive. And what was this evidence, you might ask? Well, it appears that the DNA evidence that was found in the glove box of Suzanne Morphew just happens to be that of a convicted felon who'd served time in prison, and his DNA came up in the CODIS hit. That's the DNA database for all the convicted felons. And guess what? He apparently is a registered sex offender and actually served time as a sex offender. But the prosecution didn't do anything about that, didn't follow that lead apparently. And that was sort of the general theme throughout the preliminary hearing, and it's quite evident when you read the affidavit for the arrest warrant in the Barry Morphew matter, is that the police decided that Barry Morphew was their guy, the suspect, and they literally built a case to convict Barry Morphew. Well, guess what? Good police officers don't pick a defendant and then build a case around them. They follow the leads wherever they may go. That's what a good detective is supposed to do. Doesn't have a dog in the fight, just simply seeks the truth. But when it looks like you're focusing on one individual and ignoring other evidence, well, it's not helping the case for the prosecution, which, in my humble opinion, was already weak. All right, next on the docket. Barry Morphew. Okay, Tuesday night, we were doing our live show, and the news broke that Barry Morphew, through his attorneys, a firm called Fisher and Brynsland, Byralsen. They have offices in Denver, and they have a New York office. Well, they filed a notice of intent to sue, and they are going to sue lots of people involved in the case as it relates to the prosecution of Barry Morphew. Now, it's required to give a notice of intent to sue so that everybody's put on notice. Well, there are several people being sued at the Chaffee County Sheriff's Department. The sheriff himself, which is John Speasy, Andrew Rotrich, the undersheriff, Detective Robin Burgess, Sergeant Claudette Heist-Julian, Sergeant William Plackner, Deputy Molyneux, Deputy Brown, Carrico, Himshot, and Corporal Investigator Alex Walker, both in his capacity as an investigator with Chaffee County Sheriff and as an investigator with the 11th Judicial District DA's office. Several agents Graham, Cahill, Atkinson, Honeycutt, Kobach, Adams, are all being sued from the Colorado Bureau of Investigation and from the district attorney's office. The DA herself, Linda Stanley, Jeff Lindsay, Aaron Pembleton, Mark Hurlbert, Dan Edwards, and Alex Walker. And then finally, the Federal Bureau of Investigation, Jonathan Grossing and Ken Harris. Now, what is they suing for? Well, they're not given a dollar amount because according to their allegations is that, and this is a quick summary here, it says that Mr. Morphew's basically has had his fundamental legal rights under Colorado and the Colorado Constitution, including but not limited to his rights under Frank v. Delaware and the applicable sections of the Colorado Constitution. He's been unlawfully arrested. The prosecution has withheld exculpatory evidence, unlawfully detained, malicious prosecution, false imprisonment, false and misleading statements in applications for warrants, abuse of process, defamation, invasion of privacy, extreme and outrageous conduct, intentional infliction of emotional distress, violation of substantive and procedural due process rights, and intentional interference with prospective advantage. It says that the defendant's conduct has caused significant injuries and damages to Mr. Morphew. Mr. Morphew is being forced to spend astronomical amounts of money to defend against the charges against him that are false, without merit, groundless, and defamatory. Mr. Morphew also lost his ability to work and support himself and his daughters as a result of the false charges, and due to the current bond conditions is unable to leave Chaffee County and is essentially unemployable in the county due to press conferences and podcasts instigated and carried out by the district attorney and sheriffs, and has suffered grave emotional distress. Cases like this are apparently difficult to precisely value, as much of the damages sustained is not subject to precise evaluation and calculation, and it will be determined by a jury should this case proceed to trial. They are alleging that Mr. Morphew's damages are extensive, and due to the nature of the defendant's conduct and the fact that the emotional stress will continue for the rest of his life. Now, what is the gist of this intentionally withholding exculpatory information? Well, that was the DNA evidence. Basically, and we'll try to give you the quick summary. Obviously, you know, there was preliminary hearings that were held back on August 23rd and September 17th. And then on September 26th, 2021, after the hearing had concluded and after September 17th, 2021, when the court ruled on the probable cause and proof evident presumption grade determination, the DA conveniently produced more discovery. This content-rich discovery apparently showed that on August 2nd of 2021, contrary to Agent Cahill's testimony, he and Deputy District Attorney DA Jeff Lindsay, Sheriff's Office Commander Alex Walker, and others participated in a conference call concerning the investigation of the CODIS sex offender matches from the DNA casework from Suzanne's glove box. Agent Cahill knew when he testified that the DNA from Suzanne's glove box matched DNA collected in 2 Arizona sex assault cases. The discovery revealed that based upon Agent Cahill's investigation, that there is a possible serial sex offender from Tempe, Arizona, that matches the DNA of Suzanne Morphew's glove box. However, there was no testimony regarding the Phoenix match and the known individual who retained a lawyer in August of 2021 when approached by law enforcement and Deputy District Attorney DA Lindsay. Agent Cahill did not reveal what he knew of the exculpatory information regarding a possible perpetrator of Suzanne's disappearance involved in the Tempe match. Agent Cahill misrepresented what he knew, intentionally omitted exculpatory evidence, and the numerous DAs present and advisory witnesses who knew that the exculpatory evidence on August 23rd, 2021 allowed him to misrepresent the evidence and failed to produce exculpatory evidence prior to the critical hearing. Additionally, the government agents identified have conspired to commit fraud upon the court by withholding exculpatory evidence from the defense and the preliminary hearing. Wow. Okay, we talked about this. The prosecution always has a duty to disclose exculpatory evidence because the prosecutors and the police investigating the case have an obligation to make sure that the evidence is turned over. If it's not turned over, this is how cases get thrown out and people have been sent to prison wrongfully for years and years and years. So I guess the thing that I would expect is this is a notice of intent to sue. But now the prosecutors, instead of focusing on their case in the business hand,
now have to deal with an investigation, preserving evidence to defend themselves, which may create a conflict in this particular case. There's probably going to be a motion for sanctions as it relates to the same allegation filed in the criminal case, where things are going to get, well, ugly. I told you early on, Morphew hired very, very good attorneys. My guess is, and based upon this filing, guess what? They are going scorched earth. They truly believe that their client is innocent. And frankly, it looks like there may be some evidence that is in fact exculpatory. And if the prosecution withheld that evidence, not going to be good. Not going to be good at all. We'll see where things lead. All right, let's get to the rest of the docket today.
Well, I'm sure everybody's heard about old Alec Baldwin. Yep. A woman died on the set of Alec Baldwin's upcoming film after the actor reportedly fired a prop gun on the set of his upcoming film. The film's director was also injured. 42-year-old Helena Hutchins, the director of photography for the upcoming film Rust, died after Baldwin reportedly discharged a prop gun while the film was shooting in New Mexico. The film's director, 48-year-old Joel Souza, was also injured and received emergency medical care at the Christus St. Vincent Regional Medical Center there in Santa Fe, New Mexico. Now, Hutchins died at the University of New Mexico Hospital in Albuquerque following what appeared to be an accident. Now, Baldwin is believed to have fired a single round from a prop gun that somehow struck both Hutchins and Souza. Witnesses said the single bullet struck Hutchins in the body and pierced Souza's clavicle. Authorities have released limited details thus far about the tragedy, and the incident remains under investigation. According to a sheriff's office news release, authorities are still working to determine what type of projectile was discharged. Now, Alec Baldwin said on Friday that his heart is broken after accidentally shooting and killing the female cinematographer, that he was cooperating fully with the police and was in touch with the woman's grieving husband. Now, Baldwin was taken to the sheriff's department to be questioned. He was released without any charges after giving a tearful interview. Afterwards, the 63-year-old actor was photographed doubled over in shock and grief as he spoke on the phone. Now, Baldwin is the lead actor in the film and its producer, and he's also shared a bit of the writing credits. The movie's armorer has not yet been named. Now, it's common on movie sets, apparently, for actors to use real guns loaded with blanks or dummy bullets to give a more lifelike effect in the shooting. Now, Baldwin was stunned after firing the fatal round and asked, "Why was I handed a hot gun?" But it remains unclear how a blank could have killed Hutchins or how a live round accidentally ended up in the gun's chamber when Baldwin pulled the trigger. The tragedy is reminiscent of the 1993 accident on the set of The Crow when Bruce Lee's son Brandon was shot and killed by a fellow actor. The film crew in that accident thought the gun was loaded with dummy bullets and blanks, but an autopsy revealed that Lee had a .44 caliber bullet lodged in his spine. Investigators in that shooting also probed the theory that a dummy cartridge got stuck in the barrel before the second was fired, a known hazard in shooting which can cause serious injuries or death when the second round is fired. Well, this case opens up a lot of questions and issues, does it not? First, how did this firearm get loaded? If it was loaded, was it a blank? What projectile was expelled from that? Did he pull the trigger, he being Alec Baldwin? And if he did, how was it that the director, where were they standing? Why was he pulling the trigger? Was it part of the scene? No one seems to ask that question just yet. Was he goofing around? I don't know. What about all those, rules of always treat every firearm as loaded, never point it at anyone unless you intend to shoot, always keep your finger off the trigger until you intend to fire, and always, look beyond the target to make sure you don't hit anybody. Yeah, I have those memorized. And having done a negligent discharge case just recently where the firearm, in my opinion, completely negligently discharged, there's no doubt about it, But there are people that will prosecute, I assure you, and say that Mr. Alec Baldwin could possibly be charged at a minimum with criminally negligent homicide because he was negligent in the handling of that firearm and should have treated it as loaded. Just saying. And if the law is going to be equal, you have to really wonder. Negligence is not a mental state that he intended to do something, only that, well, he fired the gun and he negligently handled it, or somebody did. Somebody's going to have to be held responsible. I'd be surprised if charges were not filed in this particular case. And Mr. Baldwin, I'm not saying you did anything wrong, but you may want to get yourself an attorney. All right, ladies and gentlemen, that's all we have for you today. Thanks for watching. Have a wonderful weekend. We'll see you next time on Crime Talk.